Section B. So how does the majority get to its rule? With text, history, and established understanding all weighing against it, the majority claims just one arrow in its quiver: the balancing test in Nixon v. Fitzgerald. Yet even that test cuts against it. The majority concludes that official acts immunity is required to safeguard the independence and effective functioning of the executive branch by rejecting that branch's own protestations that such immunity is not at all required and would, in fact, be harmful. In doing so, it decontextualizes Fitzgerald's language, ignores important qualifications, and reaches a result that the Fitzgerald court never would have countenanced. In Fitzgerald, plaintiff A. Ernest Fitzgerald sued then-former President Nixon for money damages. He claimed that while in office, Nixon had been involved in unlawfully firing him from his government job. The question for the court was whether a former president had immunity from such a civil suit. The court explained that it was settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. To determine whether a particular type of suit against a president or former president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. The court explained that when judicial action is needed to serve broad public interests, as when the court acts, not in derogation of the separation of powers, but to maintain their proper balance, or to vindicate the public interest in an ongoing prosecution, the exercise of jurisdiction has been held warranted. On the facts before it, the court concluded that a merely private suit for damages based on a president's official acts did not serve those interests. The court reasoned that the visibility of the president's office and the effect of his actions on countless people made him an easy target for civil suits that frequently could distract him from his public duties. The public interest in such private civil suits, the court concluded, was comparatively weak. Therefore, the court held that a former president was immune from such suits. In the context of a federal criminal prosecution of a former president, however, the danger to the functioning of the executive branch is much reduced. Further, as every member of the Fitzgerald court acknowledged, see Part 4, the public interest in a criminal prosecution is far weightier. Applying the Fitzgerald balancing here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity, granting Trump the same immunity from criminal prosecution that Nixon enjoyed from an unlawful termination suit. That is plainly wrong. 1. The majority relies almost entirely on its view of the danger of intrusion on the executive branch, to the exclusion of the other side of the balancing test. Its analysis rests on a questionable conception of the president as incapable of navigating the difficult decisions his job requires while staying within the bounds of the law. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. The majority says that the danger of intrusion on the authority and functions of the executive branch posed by criminally prosecuting a former president for official conduct is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability. That the president would be chilled from taking the bold and unhesitating action required of an independent executive. It is, of course, important that the president be able to deal fearlessly and impartially with the duties of his office. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing presidential decision-making is very real. Yet there are many facets of criminal liability which the majority discounts that make it less likely to chill presidential action than the threat of civil litigation. First, in terms of probability, the threat of criminal liability is much smaller. In Fitzgerald, the threat of vexatious civil litigation loomed large. The court observed that given the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for suits for civil damages. Although the effect of the president's actions on countless people could result in untold numbers of private plaintiffs suing for damages based on any number of presidential acts in the civil context. The risk in the criminal context is only that a former president may face one federal prosecution in one jurisdiction for each criminal offense allegedly committed while in office. The majority's bare assertion that the burden of exposure to federal criminal prosecution is more limiting to a president than the burden of exposure to civil suits does not make it true, and it is not persuasive. Second, federal criminal prosecutions require robust procedural safeguards not found in civil suits. The criminal justice system has layers of protections that filter out insubstantial legal claims, whereas civil litigation lacks analogous checks. To start, Justice Department policy requires scrupulous and impartial prosecution founded on both the facts and the law. The grand jury provides an additional check on felony prosecutions, acting as a buffer or referee between the government and the people to ensure that the charges are well-founded. If the prosecution makes it past the grand jury, then the former president still has all the protections our system provides to criminal defendants. If the former president has an argument that a particular statute is unconstitutional as applied to him, then he can move to dismiss the charges on that ground. Indeed, a former president is likely to have legal arguments that would be unavailable to the average criminal defendant. For example, he may be able to rely on a public authority exception from particular criminal laws or an advice of the Attorney General defense. If the case nonetheless makes it to trial, the government will bear the burden of proving every element of the alleged crime beyond a reasonable doubt to a unanimous jury of the former president's fellow citizens. If the government manages to overcome even that significant hurdle, then the former president can appeal his conviction, and the appellate review of his claims will be particularly meticulous. He can ultimately seek this court's review, and if past practice, including in this case, is any indication, he will receive it. In light of these considerable protections, the majority's fear that bare allegations of malice would expose former presidents to trial and conviction is unfounded. Bare allegations of malice would not make it out of the starting gate. Although a private civil action may be brought based on little more than intense feelings, a federal criminal prosecution is made of firmer stuff. Certainly, there has been, on occasion, great feelings of animosity between incoming and outgoing presidents over the course of our country's history. Yet it took allegations as grave as those at the center of this case to have the first federal criminal prosecution of a former president. That restraint is telling. Third, because of long-standing interpretations by the executive branch, Every sitting president has so far believed himself under the threat of criminal liability after his term in office, and nevertheless boldly fulfilled the duties of his office. The majority insists that the threat of criminal sanctions is more likely to distort presidential decision-making than the potential payment of civil damages. If that is right, then that distortion has been shaping presidential decision-making since the earliest days of the Republic. Although it makes sense to avoid diversion of the president's attention during the decision-making process with needless worry, one wonders why requiring some small amount of his attention or his legal advisor's attention to go towards complying with federal criminal law is such a great burden. If the president follows the law that he must take care to execute, he has not been rendered unduly cautious. Some amount of caution is necessary after all. It is a far greater danger if the president feels empowered to violate federal criminal law, buoyed by the knowledge of future immunity. I am deeply troubled by the idea, inherent in the majority's opinion, that our nation loses something valuable when the president is forced to operate within the confines of federal criminal law. So what exactly is the majority worried about deterring when it expresses great concern for the deterrent effect that the threat of trial, judgment, and imprisonment would pose? It cannot possibly be the deterrence of acts that are truly criminal. Nor does it make sense for the majority to wring its hands over the possibility that presidents might stop and think carefully before taking action that borders on criminal. Instead, the majority's main concern could be that presidents will be deterred from taking necessary and lawful action by the fear that their successors might pin them with a baseless criminal prosecution, a prosecution that would almost certainly be doomed to fail, even if it made it out of the starting gate. The court should not have so little faith in this nation's presidents. As this court has said before in the context of criminal proceedings, the chance that now and then there may be found some timid soul who will take counsel of his fears and give way to their repressive power is too remote and shadowy to shape the course of justice. The concern that countless and baseless civil suits would hamper the executive may have been justified in Fitzgerald, but a well-founded federal criminal prosecution poses no comparable danger to the functioning of the executive branch. 2. At the same time, the public interest in a federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Burger's concurrence accordingly emphasized that the majority's immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. At the very least, the Fitzgerald court did not expect that its balancing test would lead to the same outcome in the criminal context. The public's interest in prosecution is transparent. A federal prosecutor herself acts on behalf of the United States. Even the majority acknowledges that the federal criminal law seeks to redress a wrong to the public as a whole, not just a wrong to the individual, such that there is a compelling public interest in fair and effective law enforcement. Indeed, our historic commitment to the rule of law is nowhere more profoundly manifest than in our view that guilt shall not escape or innocence suffer. The public interest in criminal prosecution is particularly strong with regard to officials who are granted some degree of civil immunity because of their duties. It is in those cases where the public can see that officials exercising power under public trust remain on equal footing with their fellow citizens under the criminal law. The public interest in the federal criminal prosecution of a former president alleged to have used the powers of his office to commit crimes may be greater still. The president represents all the voters in the nation, and his powers are given by the people under our Constitution. When presidents use the powers of their office for personal gain or as part of a criminal scheme, every person in the country has an interest in that criminal prosecution. The majority overlooks that paramount interest entirely. Finally, the question of federal criminal immunity for a former president involves a countervailing Article II consideration absent in Fitzgerald. Recognizing such an immunity would frustrate the executive branch's enforcement of the criminal law. The president is, of course, entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. One of the most important is enforcement of federal law, as it is the president who is charged constitutionally to take care that the laws be faithfully executed. The majority seems to think that allowing former presidents to escape accountability for breaking the law while disabling the current executive from prosecuting such violations somehow respects the independence of the executive. It does not. Rather, it diminishes that independence, exalting occupants of the office over the office itself. There is a twisted irony in saying, as the majority does, that the person charged with taking care that the laws be faithfully executed can break them with impunity. In the case before us, the public interest and countervailing Article II interest are particularly stark. The public interest in this criminal prosecution implicates both the executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, as well as the voters' interest in democratically selecting their president. It also, of course, implicates Congress's own interest in regulating conduct through the criminal law. Yet the majority believes that a president's anxiety over prosecution overrides the public's interest in accountability and negates the interests of the other branches in carrying out their constitutionally assigned functions. It is, in fact, the majority's position that boils down to ignoring the Constitution's separation of powers. Section C. Finally, in an attempt to put some distance between its official acts immunity and Trump's requested immunity, the majority insists that Trump asserts a far broader immunity than the limited one the majority has recognized. If anything, the opposite is true. The only part of Trump's immunity argument that the majority rejects is the idea that the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. That argument is obviously wrong. Rejecting it, however, does not make the majority's immunity narrower than Trump's. Inherent in Trump's impeachment judgment clause argument is the idea that a former president who was impeached in the House and convicted in the Senate for crimes involving his official acts could then be prosecuted in courts for those acts. By extinguishing that path to overcoming immunity, however nonsensical it might be, the majority arrives at an official acts immunity even more expansive than the one Trump argued for. On the majority's view, but not Trump's, a former president whose abuse of power was so egregious and so offensive even to members of his own party that he was impeached in the House and convicted in the Senate, still would be entitled to at least presumptive criminal immunity for those acts. Part 5. Separate from its official acts immunity, the majority recognizes absolute immunity for conduct within the president's exclusive sphere of constitutional authority. Feel free to skip over those pages of the majority's opinion. With broad official acts immunity covering the field, this ostensibly narrower immunity serves little purpose. In any event, this case simply does not turn on conduct within the president's exclusive sphere of constitutional authority, and the majority's attempt to apply a core immunity of its own making expands the concept of core constitutional powers beyond any recognizable bounds. The idea of a narrow core immunity might have some intuitive appeal in a case that actually presented the issue. If the president's power is conclusive and preclusive on a given subject, then Congress should not be able to act upon the subject. In his Youngstown concurrence, Justice Robert Jackson posited that the president's power of removal in executive agencies seemed to fall within this narrow category. Other decisions of this court indicate that the pardon power also falls in this category. In this case, however, the question whether a former president enjoys a narrow immunity for the exercise of his core constitutional powers has never been at issue, and for good reason. Trump was not criminally indicted for taking actions that the Constitution places in the unassailable core of executive power. He was not charged, for example, with illegally wielding the presidency's pardon power or veto power or appointment power or even removal power. Instead, Trump was charged with a conspiracy to commit fraud to subvert the presidential election. It is true that the detailed indictment in this case alleges that Trump threatened to remove an acting attorney general who would not carry out this scheme. Yet, it is equally clear that the government does not seek to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. If that were the majority's concern, it could simply have said that the government cannot charge a president's threatened use of the removal power as an overt act in the conspiracy. It says much more. The core immunity that the majority creates will insulate a considerably larger sphere of conduct than the narrow core of conclusive and preclusive powers that the court previously has recognized. The first indication comes when the majority includes the president's broad duty to take care that the laws be faithfully executed among the core functions for which a former president supposedly enjoys absolute immunity. That expansive view of core power will effectively insulate all sorts of non-core conduct from criminal prosecution. Were there any question, consider how the majority applies its newly minted core immunity to the allegations in this case. It concludes that Trump is absolutely immune from prosecution for any conduct involving his discussions with Justice Department officials. That conception of core immunity expands the conclusive and preclusive category beyond recognition, foreclosing the possibility of prosecution for broad swaths of conduct. Under that view of core powers, even fabricating evidence and insisting the department use it in a criminal case could be covered. The majority's conception of core immunity sweeps far more broadly than its logic, borrowed from Youngstown, should allow. The majority tries to assuage any concerns about its made-up core immunity by suggesting that the government agrees with it. That suggestion will surprise the government. To say, as the government did, that a small core of exclusive official acts such as the pardon power, the power to recognize foreign nations, the power to veto legislation, and the power to make appointments cannot be regulated by Congress, does not suggest that the government agrees with immunizing any and all conduct conceivably related to the majority's broad array of supposedly core powers. The government, in fact, advised this court to leave potentially more difficult questions about the scope of any immunity that might arise on different facts for decision if they are ever presented. That would have made sense. The indictment here does not pose any threat of impermissibly criminalizing acts within the president's conclusive and preclusive authority. Perhaps for this reason, even Trump discouraged consideration of a narrower scope of immunity, claiming that such immunity would be nearly impossible to fashion and would certainly involve impractical line-drawing problems in every application. When forced to wade into thorny separation of powers disputes, this court's usual practice is to confine the opinion only to the very questions necessary to decision of the case. There is plenty of peril and little value in crafting a core immunity doctrine that Trump did not seek and that rightly has no application to this case. Part 6. Not content simply to invent an expansive criminal immunity for former presidents, the majority goes a dramatic and unprecedented step further. It says that acts for which the president is immune must be redacted from the narrative of even wholly private crimes committed while in office. They must play no role in proceedings regarding private criminal acts. Even though the majority's immunity analysis purports to leave unofficial acts open to prosecution, its draconian approach to official acts evidence deprives these prosecutions of any teeth. If the former president cannot be held criminally liable for his official acts, those acts should still be admissible to prove knowledge or intent in criminal prosecutions of unofficial acts. For instance, the majority struggles with classifying whether a president's speech is in his capacity as president, an official act, or as a candidate, an unofficial act. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so. He then hires a private hitman to murder that political rival. Under the majority's rule, the murder indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. That is a strange result, to say the least. The majority's extraordinary rule has no basis in law. Consider the First Amendment context. Although the First Amendment prohibits criminalizing most speech, it does not prohibit the evidentiary use of speech, including its use to prove motive or intent. Evidentiary rulings and limiting instructions can ensure that evidence concerning official acts is considered only for the proper purpose for which it was admitted. The majority has no coherent explanation as to why these protections that are sufficient in every other context would be insufficient here. It simply asserts that it would be untenable and would deprive immunity of its intended effect. The majority hazards an explanation that the use of official acts evidence will raise a unique risk that the jurors' deliberations will be prejudiced by their views of the president's policies and performance while in office. That unique risk, however, is not a product of introducing official acts evidence. It is simply the risk involved in any suit against a former president, including the private acts prosecutions the majority says it would allow. Part 7. Today's decision to grant former presidents immunity for their official acts is deeply wrong. As troubling as this criminal immunity doctrine is in theory, the majority's application of the doctrine to the indictment in this case is perhaps even more troubling. In the hands of the majority, this new official acts immunity operates as a one-way ratchet. First, the majority declares all of the conduct involving the Justice Department and the Vice President to be official conduct, yet it refuses to designate any course of conduct alleged in the indictment as private, despite concessions from Trump's counsel. Trump's counsel conceded, for example, that the allegation that Trump turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results sounds private. He likewise conceded that the allegation that Trump conspired with another private attorney who caused the filing in court of a verification signed by Trump that contained false allegations to support a challenge sounds private. Again, when asked about allegations that 3 private actors helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and Trump and a co-conspirator attorney directed that effort, Trump's counsel conceded the alleged conduct was private. Only the majority thinks that organizing fraudulent slates of electors might qualify as an official act of the president, or at least an act so interrelated with other allegedly official acts that it might warrant protection. If the majority's sweeping concession of official acts has any real limits, the majority is unwilling to reveal them in today's decision. Second, the majority designates certain conduct immune while refusing to recognize anything as prosecutable. It shields large swaths of conduct involving the Justice Department with immunity, but it does not give an inch in the other direction. The majority admits that the Vice President's responsibility presiding over the Senate is not an executive branch function, and it further admits that the President plays no direct constitutional or statutory role in the counting of electoral votes. Yet the majority refuses to conclude that Trump lacks immunity for his alleged attempts to enlist the Vice President to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. Instead, it worries that a prosecution for this conduct might make it harder for the President to use the Vice President to advance his agenda in Congress. Such a prosecution, according to the majority, may well hinder the President's ability to perform his constitutional functions. Whether a prosecution for this conduct warrants immunity should have been an easy question, but the majority turns it into a debatable one. Remarkably, the majority goes further and declines to deny immunity even for the allegations that Trump organized fraudulent elector slates, pressured states to subvert the legitimate election results, and exploited violence at the Capitol to influence the certification proceedings. It is not conceivable that a prosecution for these alleged efforts to overturn a presidential election, whether labeled official or unofficial under the majority's test, would pose any dangers of intrusion on the authority and functions of the executive branch, and the majority could have said as much. Instead, it perseverates on a threshold question that should be immaterial. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. The majority's single-minded fixation on the president's need for boldness and dispatch ignores the countervailing need for accountability and restraint. The framers were not so single-minded. In the Federalist Papers, after endeavoring to show that the executive designed by the Constitution combines all the requisites to energy, Alexander Hamilton asked a separate, equally important question. Does it also combine the requisites to safety in a Republican sense, a due dependence on the people, a due responsibility? The answer then was yes, based in part upon the president's vulnerability to prosecution in the common course of law. The answer after today is no. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. We've come to the end of this opinion. Until next episode, thanks for listening to What SCOTUS Wrote Us.